Retirement Decoded. Sunday mornings at 8. Learn more at scotttuckersolutions.com.
Now, from the Signature Bank Studios.
Only the biggest stories, only the biggest guests, and only the biggest opinions. This is AM 560, The Answer.
Top of the morning, Dan and Amy. Constitutional lawyers continue to weigh in on the Trump trial in Manhattan and conviction. Over the Wall Street Journal, David Rifkin, we've had on the show, he was in both the Reagan and the H.W. Bush administration's Justice Departments. He penned an op-ed along with a law professor from Florida International. They cite a 1948 Supreme Court case, Colby, Arkansas. No principle of procedural due process is more clearly established than that notice of the specific charge and a chance to be heard in a trial of the issues raised by that charge. If issues raised by the charge, if desired, among the constitutional rights of every accused in a criminal proceeding in all courts, state or federal. In a 1970 case, appreciate these constitutional lawyers doing this shepherdizing for us. The justices, Supreme Court justices, affirmed due process clause protects the accused against conviction except upon proof of reasonable doubt of every fact necessary to constitute the crime with which he is charged. All of these due process precepts, they argue, were absent in Mr. Trump's trial. And he was entitled to those due process rights, not because Trump says so, but because the Constitution does and the Supreme Court has so held. Mark Levin has also tweeted out another conversation he had with a Supreme Court litigator friend of his.
Okay.
The Supreme Court litigator friend said that the Republican attorneys general around the country should look to sue the state of New York. Levin, recounting the arguments, wrote, the state of New York should be sued in the Supreme Court. New York prosecutors have sought and obtained civil and criminal judgments under unique New York laws against Trump in New York courts before New York judges shortly before the presidential election. Their purpose and the necessary effect of what they have done is to interfere in the forthcoming federal election by persuading voters in swing states not to cast ballots for electors who would choose Trump to be president. The legal validity of these New York judgments has been challenged but cannot be determined before the election. He cites a 1934 Supreme Court case that even though presidential electors are not officers or agents of the federal government, they exercise federal functions and discharge duties in virtue of authority conferred by the Constitution. Therefore, the argument goes, a single state may not deliberately utilize its local laws invoked by prosecutors and implemented by judges who affiliate with one national party to tilt the voting for electors in other states, which is what they would argue Alvin Bragg has done in New York. And this would be the basis for the Supreme Court to take this matter up and take it up before the November election. Interesting. We've also heard and we've talked to Professor Epstein at University of Chicago and Professor Jacobson at Cornell about this other suggestion made by a former clerk for Chief Justice Warren Burger that under the Supreme Court's common writs power, because, as was argued in that Wall Street op-ed I was just referencing, Trump's due process rights were violated, you can appeal directly from state court to the Supreme Court, and why wouldn't the Supreme Court take this up? Well, to help us distill all of this and all these expert legal opinions, we're pleased to be joined by somebody with expert legal opinions in his own right, Andy McCarthy, former Chief Assistant U.S. Attorney of the Southern District of New York, contributing editor at National Review, author of the bestseller Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency. The plots to rig elections persist. Andy McCarthy, thanks for joining us, as always. Appreciate it.
Good morning.
So these arguments as to how to get the Trump conviction before the Supreme Court on appeal straight away, what say you to them?
Yeah, I think the case was atrocious from beginning to end. I've even argued that I think the New York statute on which Trump was prosecuted is unconstitutional under New York's Constitution, even before you get to the problems with the indictment and the trial. But I think what a lot of my friends who were talking about jumping out of the state system and into the federal courts and ultimately to the Supreme Court, or maybe first to the Supreme Court, I think that something happened in this case very early on that's pretty harmful to that effort, and that is Trump tried to move the case into federal court in, I want to say it was like May or so of 2023. And the upshot of that was, I think in late June of 2023, Judge Alvin Hellerstein, who was like a 90-year-old senior judge appointed by Clinton of the federal court in the Southern District of New York, issued a thorough opinion. I thought it was, parts of it were an awful opinion, but it did hit all the issues, even if it didn't get them right. And it essentially endorsed the strategy of Alvin Bragg that was ultimately implemented through the rulings of Judge Merchan in the state case. So it's not a situation where a federal court hasn't already passed on this. And there was a lot more discovery about what the charges were. This doesn't cure, Dan, the failings of the indictment, because a person is entitled under the Constitution to have the essential elements of a charge spelled out in an indictment. And if it doesn't, and this indictment doesn't, then the indictment fails under the U.S. Constitution. Nevertheless, they gave a lot of extra information to Judge Hellerstein about what their theories were, including that they were relying on this New York election law, and they were relying on FECA, the Federal Election Campaign Act. So I just think it'd be hard to jump into federal court now like this has never happened, when the state can wave around this opinion from a federal judge saying it was all fine.
So where do we go from here? Where does the case
Well, he's got to, obviously, sentencing is coming, and then he's got to appeal to the appellate division and pursue getting the case reversed in the New York court system. I think, I've, Amy, answered a million times to people who ask, well, if Trump gets convicted, does that mean he can't run for president? And obviously it doesn't, because the Constitution states what the qualifications are for president, and there's nothing in those qualifications that say somebody who's been convicted of a crime can't run for president. Just, I think Eugene Debs was in prison when he ran for president. But at the same time, while there's no constitutional restrictions on somebody who's in Trump's situation from running for president, I don't think that means that states can't pursue their criminal processes against people who are candidates for office.
Well, but okay, so what
I agree that
what
the New York process is corrupt, but it's their process.
Well, and so you don't think the situation would change in terms of the Supreme Court possible willingness to intervene, even if Trump was sentenced to prison and had to report on July 11th?
Well, first of all, that would have to happen first. And my understanding is the normal procedure in New York is that Trump is going to be continued on his current release conditions, which are release on his own recognizance, pending appeal. So the appeal's not going to be decided till sometime next year. I'm actually fearful of that, Dan, because it seems to me that if Merchan knows that he can impose a jail sentence without actually putting Trump in jail, that's extra incentive for him to impose the jail sentence.
Yeah, I agree.
Then he can be the progressive hero he wants to be. But Trump isn't going to be in prison. He's not going to be. Now, if it turns out that I'm wrong about this and he actually tries to put him in right there and then, I think, then we're in a different place. But I don't think that's conceivable in New York.
But the Supreme, so even with that, and it's an important issue you raised, that federal court judge that weighed in on the issue when they tried to move it. But I
Right.
mean, the Supreme Court can still look at this and say there is a colorable claim here of due process violation. It may be a colorable claim of election interference too, based on this theory by the Supreme Court litigator. And so we need to take this up, regardless of what a federal district court judge says. I mean, this is not an issue that's going to ripen because there's going to be future presidents in this situation. I mean, so the time to act is now if you're going to draw some lines, essentially.
Well, look, they can try, and they got a lot of smart people working this. My sense of what they would do is the Supreme Court probably, maybe even today's Wednesday, right? So maybe even tomorrow they could issue the immunity ruling, but it'll be, any day now we're going to get that. And that's about a very fraught issue about whether whether presidents and former presidents have immunity from prosecution. This seems to me to be, when you get all the underbrush out of the way, this is essentially an argument that presidential candidates have some form of immunity, and that's going to be. I would think if I'm the court, that may be a bridge too far given what they're wrestling with now. But look, I've been wrong before.
Well, I mean, you and by the way, you and Turley were great.
Awesome.
You guys should have your own show doing analysis for Fox.
Thank you.
But I mean, Turley thinks the Supreme Court ultimately overturns this conviction, but it won't be until after the election. They're not going to intervene. I suppose he's going. They're going to watch what the lower courts do, or the appellate court does in New York, and if they don't remedy the situation, then the Supreme Court may take it up. But his essential argument is they'll exhaust your state options before we consider a federal one.
Right. Yeah, I think that's right. And also, you have to, since we're talking about the way politics corrupts the legal system, the Supreme Court is dealing with that too. So, the left is trying to mow and agitate to get Justice Alito to recuse and Justice Thomas to recuse. And I think the latest attack is on Justice Barrett's husband, because he had Fox as a legal client or something. So they're obviously on the warpath against the conservative justices. And I don't think when they get cases that are in front of them that they have to decide, I don't think they're going to, for example, I don't think Justice Alito would change a comma of what he's doing because the left is giving them a hard time. But I think they are going to be careful about looking like they're reaching out to get a case prematurely. And ordinarily, with a state case, the Supreme Court would let it run through the state system. And there are a lot of state law grounds, by the way, to throw this conviction out, including, I think, the most basic reason to throw it out is they didn't prove their case beyond a reasonable doubt. Even if you leave all the other legal objections to the constitution of this proceeding, if you put those on the side, they simply didn't prove the case.
Well, but what was the crime?
The
I mean, it's during the jury's, the crime was misuse of campaign funds. I mean, we learned what the crime was during closing arguments, and that's a federal, not a state charge.
Yeah, so the crime technically was falsification of business records with fraudulent intent that included the concealment of a misdemeanor conspiracy to influence the 2016 election by unlawful means, if that's not enough of a mouthful for you. And the unlawful means, the judge offered them a menu of 3, but I think, as I wrote a column about this yesterday at National Review, it's a little technical for people who aren't lawyers who do conspiracy law, but it's not a crime to conspire to influence an election. I mean, influencing an election is what campaigns try to do. The thing that makes it a crime is that you have to do it by unlawful means. So the unlawful means are not exactly, they're not in conspiracy parlance, they're not means, they're the objective of the conspiracy. And when you're talking about the objective crime of a conspiracy, a jury has to be unanimous in finding that. And instead, what Judge Merchant told them is, well, I'll give you 3 choices, and you don't have to be unanimous as long as you find. I think that's dead wrong. But I don't know that you even need to get there because I don't think they proved fraudulent intent beyond a reasonable doubt, which is basic. And if the crime, the object crime, is violating the federal election law, I don't think there's a shred of evidence in the record that Trump was even thinking about the federal election laws, much less aware of them and trying to flout them when the NDAs were being negotiated in 2016 and when Cohen was being paid in 2017. And if you don't prove that he willfully violated federal election law or was trying to beyond a reasonable doubt, then you don't have a case.
In the last minute we have you, it's been a while since I've took criminal law in law school, so perhaps I've forgotten the nuances, but is it important to have a confession if you're a prosecutor? Because it seems that that's what prosecutors in the Hunter Biden case have, a confession.
Yeah,
So
he wrote a book.
are we just going to have the prospect of jury nullification for politics? Is that what this case is?
I don't think so. I think, I heard my friend John Turley say that, and he's right that they're trying to get a nullification from the jury. And obviously, Delaware's small. The Bidens are very powerful. They have reason to hope for that. But I actually think what they're trying to do is set up the case for appeal. They want to take the position that the Second Amendment, that under the Second Amendment, unless somebody is debilitated by drugs at that moment when they obtain the gun, then the Second Amendment protects you. And what's going to happen in this trial is Judge Noreika is going to instruct the jury. It doesn't have to be this second. It's got to be sometime proximate, sometime around the time of the purchase. And I think what these guys are doing is it sounds like they're pursuing a defense that can't win on trial, but that's because when they get up on appeal, they want to preserve their ability to argue that she misinterpreted. That's Judge Noreika misinterpreted the Second Amendment.
Won't that be fun? An expansive reading of the Second Amendment to save a Biden.
It's
that's going to be
classic.
beautiful.
The Bidens, right?
You can't make this stuff up. This is the greatest thing ever.
I'm not.
Andy McCarthy, former Chief U.S. Assistant Attorney, Southern District of New York, contributing editor at National Review, author of the bestseller Ball of Collusion. Andy, thank you as always. Appreciate it.
My pleasure. Have a great week, guys.
Thank you. And he joined us on our turnkey.pro answer line. All right, coming up on Chicago's Morning Answer.
Republicans are embracing vote by mail in Pennsylvania, writes Selena Zito. We'll get an update on vote by mail programs, election integrity, ballot security, all those important mechanics of the administration of the November election. Ken Cuccinelli, former Virginia Attorney General, now national chairman of the Election Transparency Initiative at 7:07.
But now let's head straight into that newsroom for news here at home and around the world. Here is Mike Scott.
Governor Pritzker decided